We're going to try to get started right on time here. I see everybody got the 5 o'clock wake-up call. So we'll begin here with the new Rule 506 requirements. Amy Martin, Linquist and Benham here in Sioux Falls.
Good morning, everyone.
Good morning.
Thank you for coming and being here so bright and early. I'm glad the rain died down so that you can hear me. I was joking with my husband, who's a litigator trial attorney. He said he wouldn't be making it up this morning for the securities talk. So I thank you all for being here. There's some very exciting changes happening in the regulatory world pertaining to securities offerings. 506, Rule 506 offerings, we're going to go through the regulatory landscape of where this fits into the securities offering landscape. Rule 506 has been broken up into 506 A, B, C, and D. I'm going to start with a background of general securities laws, and then I'm going to jump into what's new. And 506C is what we're going to concentrate on. So just a general background, putting public and private securities into context here. Section 5 of the Securities Act governs exempt transactions and exempt securities. So when you raise money for a private equity client, say a hotel client, say a restaurant client, somebody that's raising money for an ethanol plant, for any type of private securities, private equity fundraising, you would go through the process of determining whether you have an exempt transaction or an exempt security. More likely than not, you're going to fall into an exempt security. An exempt security, there are 3 types of offerings that you would do. You would do a 504 offering, a 505 offering, or a 506 offering. Given the limited time, I'm going to skip the first 2. The most common type of offering that is done with regard to private equity fundraising is a 506 offering. What is different and what changed in September of 23 is September 23rd of 2013 is under the Jobs Act. The Jobs Act required there to be a lift of the general solicitation prohibition. So when you raised money under a prior 506 offering, there had to be a substantial relationship between the offerer and whoever they were selling the securities to. I couldn't go to my class reunion of 1989 and send out an email to everybody that was there and say, hey, I'm raising money for this great project. I don't know everybody in my class, send me money. I couldn't do that under a prior 506 offer. I couldn't put up a billboard and say, hey, I need money for this great new hotel that's going up on the end of town. That would have been a violation of a 506 offering, and it would have blown your exempt security status, so then you would have had to have registered or started all over and done what's called a rescission, offered people their money back and then do it the correct way. What the Jobs Act promulgated was a requirement that now, given the social media atmosphere that we're all practicing law and raising money in, that we should be allowed to generally solicit and get private equity funds. It should not be something that I have to have a personal relationship with you, because people meet over the internet. People meet in so many different ways now. And so what the government did is they came back in and rewrote 506. So again, 506 used to have a prohibition on general solicitation and general advertising. That ban has now been lifted, and you can elect whether or not you want to stay under the old laws and do an old 506 offering, which would be 506B, or 506C is the new offering that you can do that allows you to generally solicit. And the key question that you're going to ask, because there are new requirements under 506C, is whether or not you want to require the offerer to verify the accredited status of the person that wants to invest. That's the key consideration, accreditation. And that's what everybody's talking about in the industry right now. What what the offerer has to do, or the issuer has to do now, is verify the accredited investor status of anybody that comes to them and offers. So I'm going to use AngelList as an example. AngelList is an online clearinghouse, so to speak, for private equity offerings. And I can post on there, hey, I have a private equity offering under general solicitation. I'm going to do it under 506B. The government is going to require me to verify that they are accredited. And that's an additional step. Under the old 506, which is the new 506B, self-certification was enough. So if you did a private equity offering, you have your subscription booklet, that you send out to all potential investors. They just check the box. Yes, I'm accredited because I make this much money. Yes, I'm accredited because I have this much net worth. They check the box, they sign it, and they send it in. And under the old offering, that was sufficient. If I'm going to generally solicit, if I'm going to put up billboards, if I'm going to be on the internet, I now have to self-certify. So I have to require them to provide either me as the issuer, documents, tax returns, and it's itemized in the statute what they all have to provide, but tax returns, bank statements, other financial data. And do you want to put the issuer in that position to be in possession of that financial data? And our industry, and most of what I have heard, is that you need to be very careful on advising your clients to take ownership of that verification process. And so what you see now is lots of companies on the internet, as well as accounting firms, offering a verification process. And that's what I'm directing my clients to do. I've actually done a couple 506 offerings. I am requiring an accountant to certify, or a financial advisor, or using a third-party third-party verification company to verify the status. It gets very dangerous if your client has all of that information. And that's something that the industry is trying to figure out, is how that verification process will go. I want to just skip real quickly to the other big change is 506D, bad actors, disqualification of felons and other bad actors. So this comes under Dodd-Frank. We don't want bad people involved with money in the United States, basically, is where this arises out of. So under Dodd-Frank, at the same time on September 23rd in 2013, they required under a 506 offering that you cannot have any felons or other bad actors involved in a private equity offering as an officer, as an issuer, as somebody who's selling securities going forward. Now, if you have an existing offering and you have a bad actor involved, then you need to do a disclosure and tell everybody that you have a bad actor involved, which is very unfortunate. I have had clients that do have bad actors in their organizations. Everybody has a slip-up every now and then. Some slip-ups are more serious than others. So what you can do is remove them as an officer for the period of the duration of the offering, or you can make a disclosure. Just be very honed in on this 506B, because you do have to make a disclosure with regard to this when you file. The filing requirements have not changed with regard to what you file. It's still within 15 days of the first sale, you would file your Form D. And Form D is the regulatory document that allows you to do an offering. And now you have to check the box on the Form D whether or not you've done a 506B or a 506C offering. So in summary, there have been no changes in Reg D offerings over the last 20 years. This is the first significant change that's happened, and it's been promulgated in large part by the social media and how we interact with people, and whether or not you can raise funds now by not having a direct personal contact with somebody. Now you can do it by billboards, you can do it by email, you can do it by registering on AngelList or other sites on the internet. That is the big change. And so 506B is your old offering. 506C is if you want to generally solicit and generally advertise. That's the fastest I've ever talked. If you can believe that. Thank you. Any quick questions? I think I have a minute. Thank you very much.
Thank you, Amy. Next, we will have the Honorable Heidi Lindgren, Magistrate Judge from Rapid City, to discuss civility in the law.
Good morning. I did pull the fire alarm to try to generate some more traffic here at the CLE. It's kind of backfiring a little bit on us because the chairs are still pretty empty, but I think my 10 minutes here is to try to generate and maybe lecture a little bit, but also compliment everybody in the room from the South Dakota Bar's perspective. Actually, in coming out here, if you haven't heard my story yet, the true definition of civility, I think, is being trapped in a beer cooler just north of Humboldt, waiting out a tornado with 30 other people, children and adults alike, trying to strategize as to whether or not, if my last few minutes are determining whether or not I'm going to drink Heineken or Bud Light, how to negotiate the 12-year-old off the Bud Light who's used it as a bench to rest them. My point today is I want to compliment you, but I've also seen a lot of things on the bench. My background, just to give you a little bit, I clerked for Judge Kornman right out of law school. I went to the Public Defender's Office in Pennington County, who they're all here, I think, in the back corner. And then after that, I went into private practice for a couple of years with Tim Wrench, doing primarily criminal defense. After 3 first-degree murder trials and a man walking out of my office and killing somebody, I decided that I was going to go work at Target, give my bar license back, and I was done. Larry Long, who I wish was here this morning, called and asked if I would prosecute drugs West River. Larry Long gave me the best piece of advice as a prosecutor. So anybody who's a prosecutor in here, this message is for you. Just because you can does not mean you should. I see mostly criminal stuff, so to the civil bar out here, I think this applies if you can put it in your practical daily living. But I see a lot of stuff where there's some power and it's misused, or it's used as kind of a tool to say, I can do it, so I'm going to do it. As a defense attorney, Mike Stonefield, who is the head of the Public Defender's Office in Pennington County, also gave me a pretty valuable piece of advice. Mike, for those of you who may have known Mike, he's on the Baseball Hall of Fame Tour circuit now, retired. But Mike sat me down and he said, sometimes the only dignity that the people that you're respecting or that you're representing have is for you to be dignified in the way that you represent them. So whether it's a criminal case, whether it's a civil case, use dignity. For the most part in South Dakota, we get complimented. The basic seminars and different things that I've gone on, we have been complimented huge about our civility, but I still see it. I'm kind of in the middle generation now. The older lawyers, please keep giving advice to the younger lawyers. The younger lawyers, please listen, because when I first came out and I was, again, criminal law, I got some of my best results as a defense attorney and some of my best results as a prosecutor by sitting down and just having a civil conversation. Sometimes the fighting, we all have lives, we all have personal things going on in our homes, we all have tragedies, we all have hurdles that we're facing. We fight, that's what the general nature of our job is to fight and to argue. But we all have lives and we all are human beings. So what I see from the bench's perspective, which has been an interesting perspective, is that those that are respected the most are the ones that take 5 minutes and just act like a human being. I feel like I'm lecturing people who are older than me and that have a lot of experience, but it's interesting when we all get caught up in the passion of what we're doing to become angry and to make it personal. It shouldn't be. The other thing that I want to convey, I guess, essentially, I think that I was asked to be a cheerleader to keep promoting us as far as civility is concerned, is just simply that everything you learned, or everything you know right now, we did learn in kindergarten, and it's just to be respectful to everybody else. I have an example. I heard somebody, and it really actually kind of made me feel bad, because again, I came in a generation where people got along and you kind of maybe solve things at the bar or you solve things at lunch. And one side, it doesn't matter where it comes from, but Someone from the opposite side said, if you ever went to lunch with the other side, that would be a fireable offense. So depending on where you're at, we're all human beings and we all have a job to do, but the most respect that you can have is the respect for yourself and the dignity for your clients. Because whether it's criminal work, whether it's civil work, whether you're doing wills and trusts, whether you're sitting on the bench, whether you're sitting in your office and you do transactional work, when you go to represent somebody, represent them with dignity. I thought when I was preparing the speech, I went, and it's really sad to me that when I Googled civility of lawyers, there are 850,000 hits on Google. And it was, take away some of the things that Amazon was advertising for books and things like that. When you read the articles, it's pretty sad to see the way that people have behaved across the country. I never saw one of those examples from South Dakota. States, California was the most recent at the beginning of May. Nevada, they did it in March, are actually requiring lawyers when they take their oath to essentially put in language that they'll behave and act like human beings in representing their clients. They're changing the language based on integrity, and I think that's wrong. I don't think that we need to be told as professionals that you have to behave, and I don't think that you have to swear as an oath to behave. I think you need to behave because that's the way it should be. And I guess in closing, because I think my time is getting close. Okay. I offer this. I wasn't going to get too personal or emotional, but I offer this. Everybody has something going on in their life. You've heard the quotes before about, treat somebody as you'd be treated because you don't have any idea what went on in their house the hour before or the 40 minutes before or the night before. I think that it's important that we all get together and that we rally together because we are a small bar and we're a close bar, but fighting just to fight isn't worth it. If you Google, and I started to do a PowerPoint, I could have given you all kinds of articles. Just Google civility and lawyers, and it's pretty sad. Because the other part of it is, we can hear lawyer jokes, you can walk in a room, you can hear everything that people have to say about lawyers, and the reason that lawyer jokes exist is because of the behavior of lawyers. So it's only up to us to change that. And I thank you for the opportunity.
Next up, Elder Law Nursing Home Law Developments with Aaron Eastland of Johnson Eastland in Rapid City.
Success. The materials you have in your book are much longer than what I'm going to be talking about. I cut this down. This was a really long presentation, but I didn't really know what I wanted to talk about, and then it's kind of hit me here. We're going to play a little board diagram. Who's done a power of attorney? Had a guardianship? Living will? The real question that I have for you is, well, I opened the wrong PowerPoint. So we're going to cut to the end. Do you have this in there? Because what we're finding more and more is people are doing powers of attorney things and they're not putting a limitation on your power of attorney to keep the power of attorney from signing a pre-injury arbitration agreement. Now, why is that important? A pre-injury arbitration agreement means we don't get to use the court system. You don't get to use wonderful judges that we have sitting in the room. You don't get to use juries. Case gets decided in an arbitrator's office somewhere out of sight. And why is that important? Well, we're cutting out what we have in the United States, which is the jury system, which is the most important thing. Because if you're going to prosecute a case, there always is an end goal. It's to right or wrong, but it's also to protect folks from that wrong occurring again. Because when they see what trouble you can get into, it doesn't happen again. I want to back up and tell you a little story. We had a case here not long ago, and it came out of a place that's less than 2 miles from here. And the lady was at her home, fell and broke her arm. She went to the nursing home, and she was there for 23 days. And you probably saw, because I went by awfully fast because I've got this backwards out of order, and this isn't kind of really for the faint of heart, but this is Emma. And Emma had a sore rear end. And she was in the nursing home for 23 days. And she lost 22 pounds. And that's what a stage 4 bed sore looks like. And when that wound comes off, it looks like that. And those are ugly pictures. But that story got told in a lawyer's office instead of in the courtroom. That happened here in Sioux Falls, less than 2 miles from here. And Emma passed away. And I met Emma when that family brought me to their house. They didn't trust the nursing homes anymore. And they had a bed put in their living room. And she lay there and spent her last days with her family. But that story needs to be told. And the family wanted it to be told. And that's why they told me I can show those things. Because it's important for everyone to understand what happens. What happens that's wrong, that needs to be right. And the way that gets done is by using our jury system. It's done by following our statutes that we have in the state. It's done by trusting the juries of the state, the people of the state, to right or wrong and get things the way they should be. We heard a little bit from Heidi, the classmate of mine, and everything she said is so right on. But when you're talking about dignity and respect of the lawyers, we got to respect the elderly people. Because in another nursing home, about 3 miles from here, is my grandmother. And so these things are very personal to me. So I just want to make sure that the folks in this room understand when you're doing those powers of attorney and things like that, you really know what they're actually signing and what actually happens. Because that family didn't know they signed an arbitration agreement. They didn't know their story wasn't going to get told. This is what goes on now. This is where companies put together groups of investors to buy nursing homes. And it's gotten bigger and bigger.